State of the Commonwealth of Massachusetts. Court is now open. Please be seated.
SJC-10934 Alliance to protect Nantucket Sound versus DPU.
All right, let's proceed. I notice on the first two cases we have a number of different lawyers participating. We've got 5 lawyers on the first case. You know how much time you have. The light system will tell you when your time is up, and we're going to ask you to cooperate with the time. Thank you.
Good morning, and may it please the court. My name is Evan Lawson. I represent the Alliance to Protect Nantucket Sound, and I will be arguing the issues of the Commerce Clause violation and the cost-effectiveness argument on behalf of all the appellants. Essentially, Section 83, which is the statute and issue in this case, mandates the purchase of electricity from renewable resources, but clearly discriminates against interstate commerce on its face because it prohibits the purchase of that electricity from sources located outside of Massachusetts.
Well, that's been suspended, though, hasn't it, that provision in the statute?
It has been suspended, but the actions that we're complaining of all took place under that restriction, were influenced by that restriction, and if the court were
But
to...
the private parties say no. No, yeah, okay, fine. No, we want to do this. We want to enter this contract.
Well, if consider this. You pass an unconstitutional statute, someone takes action, creates something that the state has to approve, and then the remedy is, well, we'll repeal the statute, and everybody's going to come in and say, oh, we would have done it anyway.
Well, they showed it. They showed that they did it anyway, didn't they?
They did not really show that they did it anyway. To me, the only remedy for, remember, the violation here is the exclusion of competitors from the market.
But even if you say it wasn't there, I mean, there is no obligation if you're looking at the individual negotiation part of the statute. There's no obligation that they have to negotiate with somebody out of state, right?
Well, then that then plays into the cost-effectiveness argument, because if they only do a sole source negotiation, which is what the New England power generators will be discussing with you this morning, then there's no way that you can determine whether what they're doing is cost-effective. If they simply go to one vendor and have no knowledge of what other vendors would have proposed and what in a national marketplace out-of-state vendors would have proposed.
Are you saying that they have to be the cheapest?
No, I'm not saying that they have to be the cheapest, but the statute says they have to be cost-effective. Now, that is part of my argument, so I will say that I think cost-effective has to be given its ordinary meaning, which is essentially as a synonym for economical, to achieve a result at a reasonable price.
Well, but there's
for the ratepayers.
There's an additional factor in there. It's for and the benefits that flow from this contract too, and you have to examine what those benefits are.
Well, let's examine that exactly, because what the DPU calls unquantifiable benefits, we would call opportunity costs. And our analysis is that, for example, if you take every one of those, and I'm just going to jump into that part of the argument without abandoning my Commerce Clause argument, but if you jump into this, the unquantified benefits, according to the DPU, that make this contract cost effective. Without these unquantified benefits, this contract could not be cost effective, because it is going to cost the ratepayers $1 billion more to purchase power under this contract over the life of the contract than it would cost them otherwise. So for this billion, what are the ratepayers getting for this extra $1 billion that they are paying? They're helping National Grid meet its renewable energy portfolio standards. Well, if they have $1 billion to spend on buying additional power, the ratepayers could get $1 billion more renewable energy, and therefore National Grid would be better able to meet its renewable energy portfolio standards. And, by the way, helping National Grid meet its renewable energy portfolio standards is not necessarily something that is a matter of cost effectiveness to the ratepayers. The second,
That again assumes cost effectiveness as lowest price, and your touchstone seems to be lowest price as
Well, no,
compared.
that-
I know you say no, but then you go back to the basic definition of what's cost effective, and then which doesn't seem to allow for not price-based benefits. So if you agree that there are non-cost-based benefits, and you don't agree that they are greenhouse gas emission reductions, enhancement of reliability of electricity supply, moderating system peak load, hedging the price of electricity over time, things like that, what do you agree are appropriate considerations apart from lowest price?
I think those are appropriate considerations, but they have to be considered as opportunity costs, so that and this is a weighing process that DPU did not do. Let's talk about enhancing reliability. Or let's think about the obvious one, hedging the price of electricity. Well, you can hedge the price of electricity by paying $1 billion more for electricity provided by Cape Wind, or you can hedge the price of electricity by having $1 billion more to spend on electricity from a variety of sources. Now, I'm not saying how you would ultimately get to play that calculus, but that was not a calculus that DPU engaged in. The DPU essentially abdicated its responsibility to weigh the opportunity costs.
Yeah, but there are other kinds of benefits, and didn't DPU say that the electricity output from Cape Wind project will significantly exceed that of eligible land-based projects, which is critical to the peak hour usage? And the other thing they said, it was because it was geographically closer to the peak hour usages, it would have an easier ability to connect to that regional grid, and that those were two identifiable benefits.
That gets me back to the pernicious effect of the constitutional violation. DPU said these things without having the benefit of knowing what was available in the marketplace. And of course, we know from the NSTAR experience, which is something perhaps for the second case, but depending on how this goes, I may not need to argue very much more in that case. We know from the NSTAR experience that when DPU forced NSTAR to enter a constitutional process, the net result was a PPA that was $139 million less than the PPA under the unconstitutional process, and satisfied all those criteria.
But didn't DPU consider land-based projects that were in New England?
Well, DPU, the record is not really clear as to what extent DPU considered those things, and we know that, for example, the Trans-Canada project in Maine was not considered. That did not have the opportunity even to make a presentation in terms of what it could do. And this, since I have only a minute left, this also plays into the so-called gap analysis. One of the supposed benefits of this contract was that it was going to deal with the gap, meaning some shortfall between production and demand in the future. Now, we don't agree that there really is a substantial evidence basis to conclude that there is a gap, but certainly under a market-based system such as we have, the market is designed to balance out supply and demand through the mechanism of price. And what the DPU did here was it said that the DPU ratepayers should pay $1 billion more for Cape Wind's energy so that some other ratepayers in the future will be able to pay less because the gap will be reduced. And that can't be cost effective to the Massachusetts
But the
ratepayers.
statute specifically allows that, doesn't it?
It requires.
Allows above market costs to be allocated among all distribution clients.
It requires cost effectiveness. Now, the allocation is
Well,
something that.
But in the consideration of cost effectiveness, it allows certain factors that you don't seem to be willing to
Well,
acknowledge.
the allocation argument is actually Associated Industries' argument, and I think they have a fairly persuasive argument that the statute really doesn't allow what DPU did in this case, which is a hybrid allocation, not warranted by the language of the statute.
Thank you.
Thank you.
May it please the Court. My name is Richard Canoff, and I represent the New England Power Generators Association. I'm going to limit my presentation to 3 main points this morning and leave the rest to briefs. The first point is that this was a sole source procurement, and it's undisputed in the record and in the briefs that the Cape Wind PPA came from a sole source procurement of an offshore wind project. Cape Wind and National Grid simply negotiated the principal terms of the deal and then executed a PPA, which they then submitted to the department for approval. There were no, as part of the negotiation process, there were no multiple players involved.
I thought the Attorney General got involved as well.
The Attorney General, Your Honor, made a settlement later on in this case, but in terms of the actual negotiation of the PPA as originally proposed here, it was just a unilateral negotiation between Cape Wind and National Grid.
Well, wasn't there some provision for individual negotiation?
Yes, Your Honor, but the individual negotiation is not a substitute for the requirement under Section 83 that there be more than one solicitation, more than one proposal. The language of the statute is clear that the distribution company, National Grid, is required to solicit proposals, not one proposal, but proposals from renewable energy developers, that's plural, and reasonable proposals need to be received. So there's no substitute for the requirement that there be more than one proposal, even though they can do an individual negotiation process with one off-taker. And a similar, in a similar
what
case,
does individual negotiations mean? Doesn't it imply that if there appears to be somebody, some entity out there with whom the National Grid could come up with what they think would be a cost-effective and feasible project, they could approach that entity directly and enter into negotiations and enter into negotiations with nobody else, at least for that particular proposal.
The requirement is, as we read the statute and as in the context of the statutes that have been promulgated in the past, is they can do an individual negotiation, but the process by which they create the universe of possible opportunities needs to be a competitive process. For example, in the NSTAR case, which came out right before the Green Communities Act was passed, there was a solicitation of interested developers for renewable projects, and NSTAR was able, as part of that solicitation then, to go and individually talk with some of the participants, but there was no exclusion of the potential universe, and this is our key point.
But there's a series of approaches that can be taken, one of which is the public solicitation. The other one is individual negotiation. And there's a third clause in the statute that says, or other methods.
The other methods are methods that are part of the solicitation of proposals. It's not a, it doesn't negate, the individual negotiation process doesn't negate the need in the context of the Restructuring Act, in the context of the need for multiple competitors to be able to have opportunities here. It doesn't negate the need for a wide universe of participants. If you were to decide that that was the case, what would happen is that every distribution company in the procurement of renewable power would be able to negotiate independently with one entity and strike a deal and present that deal to the department. That would put all of the prior Restructuring Act and all the prior legislation that went into creating the competitive markets on its head. There would be no longer any type of competitive process available to procure electricity supply in the Commonwealth, and that's never occurred. This is the only case where a sole source procurement for renewable power since the Restructuring Act was promulgated, and since in anything longer than 1 year where it was a sole source procurement.
Now, the AG says you've waived your ability to appeal by not challenging the final decision in DPU 09-138.
As we note in the brief, Your Honor, that is different issues, different parties, and in that case, if you look at the detail of that case, merely has to do with giving Cape Wind permission to negotiate with National Grid. It doesn't obviate the need as part of that permission, as part of that negotiation, for them to then comply with all of applicable statutes, laws, and regulations. And it's our position that they didn't do that because they engaged in a sole source negotiation.
Are you saying that the individual negotiations is that there's some policy out there or some other statute that renders this illegal? Or are you saying that it's imprudent to do it this way because it will exclude competitors?
We're saying that it's not allowed by Section 83, the plain meaning of Section 83, and it's not allowed by the plain reading and specific provisions of Chapter 164, 1BD, which requires a competitive solicitation, competitive bidding. So we're saying it's not allowed.
In the legislative purpose to try to encourage the development of renewable energy in a cost-effective manner, you're saying that goal of the statute is inconsistent with the approach that the Attorney General is espousing now.
The goal of the statute to encourage renewable development is a goal that's been in existence since the Restructuring Act was passed, and it was appreciated, recognized by the Department in its consideration of NSTAR Green, which is cited in our brief, which actually is under 1B, and the Section 83, the publication of Section 83, just continued that emphasis, but didn't change the requirement for a competitive process, which is fundamental.
Thank you, Counsel.
Thank you.
Good morning. May it please the Court, my name is Robert Rio. I am counsel for Associated Industries of Massachusetts. I'm here to talk about two issues, the cost allocation issue and the cap issue, neither of which have been previously covered. The Department misinterpreted both of the sections dealing with the cost allocation and the cap on the purchase of renewable power. And because of that, it's a fundamental flaw. Not only is the order incorrect and inconsistent with the Green Communities Act, but in fact, those two areas violate the Restructuring Act, which is still the law of the land. In my brief, I pointed out there is no explicit or implicit notice in the Green Communities Act that overturned any section of the Restructuring Act. So the two have to be read in harmony, and the only way to read them in harmony is to dismiss and remand the Department's order. As to the cost allocation, the legislature was trying to maintain the basic tenets of restructuring, where you have two classes of customers. And when they developed, because they're trying to keep it in harmony with the Restructuring Act, and in the Act, the Green Communities Act, it allows the distribution company to either sell the power they procure to their basic service customers or sell it into the market. And in that case, and only in that case, could they take the delta difference, whether it's higher or lower. In some cases, it could be lower. In this case, it is higher. But they could take the delta difference between what they sell it for in the market in an auction and what they sell for, and then take that and then what they paid for it. So the delta between what they paid for it and what they sell it for. And then they can take that difference and charge it to all distribution customers, those on competitive supply and on the basic service. National Grid is not doing that. What National Grid is doing is they are using all the power for their basic service customers. However, they're coming up with a proxy, if you will, for selling it into the market, and then they're taking that difference and charging all their distribution customers. And that is a violation of the Restructuring Act, because what you have now is you have the competitive service customers who are now subsidizing, who have to, by the way, the competitive service customers have to go out and buy their own power, and they have to go out and buy their own renewable power to satisfy the law, but they're not getting any benefit of the Cape Wind power. They're just paying for it, because all the renewable energy requirements are being met by Cape Wind on their basic service customers. So the basic service customers are getting an ability to make the renewable standards in Massachusetts, but the competitive service customers are getting nothing, and they're just paying extra for it. And that is a violation. And if we carry, since the DPU ruled that there was no cap, that you could go above 3%, we, of course, have argued there is a cap. If this were to continue and continue and continue, and you would go to 5, 6, 7, or 10% of National Grid's load, you could see how the competitive service customer would continually pay more and more and more just to subsidize the basic service customer, while the competitive service customer is getting nothing for that extra money they're paying, because they have to go out and procure their own power. So they're essentially buying their own power, then they're buying a little bit for the basic service customers. And in no case under restructuring is there a case where either side subsidizes the other. Now, it's possible for it to go the other way too, which is even more egregious, because now you'd have basic service customers subsidizing the competitive supply customers, and we think that would be wrong too. So in either case, whether it's an above market contract, as in this case, or if it's a below market contract, one side would be subsidizing the other, essentially destroying the competitive supply requirements in the Restructuring Act, which has been the law of the land for 13 years and has worked very, very well. National Grid can cure this by just selling it into the market. It's very explicit in the law that in order to take the delta and distribute that cost to all their distribution customers, they sell it into the market, establish a real auction price, and once they do that, they are okay to do exactly what they did. But there is nothing in the law that would allow them to use this power to satisfy their own customers, yet charge everybody else in their distribution. That is completely in violation of the Restructuring Act and would completely be illogical if more contracts are signed. And as to the cap, we have submitted evidence that the cap is 3% under the Green Communities Act for Section 83 contracts. And we have submitted, my time is up, but we've submitted a lot of contemporaneous evidence to show that those people in the knowledge, including general counsels of the agencies overseeing this law, have also indicated that this Section 83 was designed to be a pilot at a cap, which leads right into the harmonization with the Restructuring Act.
Let me just ask you a question, if I might. I really wasn't sure that I understood what you said when you said National Grid can cure the problem by just selling into the market.
Yes.
So they sell into the market. Let's assume they sell into the market at a price lower than what they have purchased. Yes. Then who pays the delta?
In that case, because you're establishing a real price in the auction in accordance with the law, that delta would indeed be washed to all the distribution customers, because nobody's...
Both the competitive ones
yes,
and basic service?
That is allowed under the law. That clearly is allowed under the law. And the reason for that is because not one set of customer is getting any benefit. See, the competitive service customer and the basic service customer are all paying equally for that power, which is now part of the market. Under the National Grid interpretation, the basic service customer is getting all the benefit, but the competitive supply power is, competitive supply person is paying a portion of that. So yes, that would be allowed under the law, and we're very, very comfortable. In fact, other utilities have done that, exactly that.
Okay.
Okay?
Thank you.
Thank you, Your Honor. Thank you.
Good morning. When electric distribution companies enter into long-term contracts under Section 83, they're no longer in the regulatory world where all that matters is cost and competitive bidding is always required. The legislature concluded in 2008 that ratepayers need construction of new renewable energy sources, and it came up with Section 83 as a way to make that happen. The statute expressly required both National Grid and the department to take into account potential costs as well as potential benefits and compare the two. Until this morning's argument, no petitioner had challenged the department's findings that the unquantified benefits to National Grid customers alone outweighed the above-market costs of this contract, which, by the way, are not the $1 billion figure that the Alliance keeps citing. The department's finding is that the above-market cost is likely to be in the range of $420 million to $695 million.
That's over 15 years?
That's over 15 years, net present value.
All right.
And one of the differences is that the Alliance likes to not look at the department's findings, but pull a nominal figure out of the record and ignore the net present value findings by the department.
Now, I'm still struggling with this definition of cost effectiveness. Now, in first-year economics, we learn about Pareto optimality, which is if you can get the same thing for less, then you're not in a Pareto optimal situation. You need to move there.
Depending on your starting point, that's right.
Right. If we were to find that you could have gotten, or that National Grid could have gotten the same thing for less, would that then show that it's not cost effective for them to have done what they did?
No, and the suggestion by the Alliance that the department failed to address this question is incorrect. The department found, as the Alliance suggests, that if cost were the only factor, that onshore wind is cheaper per megawatt than offshore wind. And this is at pages 226 to 234 of the order. The department went on to find that under the statute, the legislature didn't use the language of Pareto optimality. The legislature directed the department to take into consideration both the potential costs and benefits. And the department found that the benefits to ratepayers of this contract outweigh the additional costs compared to other renewable energy.
Would you agree that if those benefits can be obtained for if those same benefits can be obtained for a lower cost, that it's not cost effective?
Perhaps, but what the department found is that this contract offers benefits that cannot be obtained from other contracts, that offshore wind has a substantially higher capacity factor, so it goes a lot further to meeting the renewable energy source gap. We're meeting the requirements of reliability, and significantly, the peak load capacity of wind generating facilities in this location is substantially higher than onshore wind or other competitors. It's higher not only on a seasonal basis, but one thing that's vitally important for making sure that there's enough peak capacity for the region, you look at the 10 highest demand hours as a typical benchmark. Here, the capacity factor for the Cape Wind facility, if it had been in place historically, would have been 76%, more than twice the average 37% capacity factor for the facility. The benefits compared to onshore wind were substantial here. That was the department's finding, and no petitioner has made a claim that that finding was unsupported by substantial evidence.
So then, would you say then that cost effective means not only that the costs exceed the benefits, that the benefits exceed the costs, but also, taking the opportunity cost argument that they make, that the same benefits cannot be obtained at lower cost?
The department analyzed it slightly differently. Although the department evaluated all of these questions, the department felt that analytically there were two distinct things it had to do. It had to evaluate cost effectiveness on the terms set forth in the legislation, comparing cost and benefits. It also found, under general rate-setting requirements, that it had to find that this contract was in the public interest. And the unique benefits, Justice Gantz, that we were just discussing, the department addressed under its public interest analysis, not under its comparison of cost to ratepayers versus benefits to ratepayers.
On that latter point, I mean, the argument is that that in looking at the cost of these benefits and lower costs, that the department really did an inadequate job at looking at alternatives on wind power or, on land wind power or other alternatives.
That claim was made today. There was not a claim in the brief or even the reply brief that finding was unsupported by substantial evidence, and there's a reason why that claim was not made. It is well supported by substantial evidence. It is undisputed that the onshore wind per megawatt could be cheaper. The findings that I was just reciting about capacity factor, the findings about location and proximity to the large customer load center that exists on Cape Cod, those facts were essentially undisputed in the record. There was a lot of contentious debate before the department, as there is before this court, about whether the department should have essentially ignored those benefits and instead required that the lower cost resources be the ones used by National Grid, even if they resulted in fewer benefits going to ratepayers. But on that issue of statutory construction, the department submits that its statutory construction is either required by the plain language of the statute or at the very least is a reasonable reading of language that the legislature charged the department and not the petitioners with construing.
Could I get you to explain how you interpret the reference to individual negotiation? Does that mean that only one possible source can be negotiated with, or must there be multiple sources?
The department found that individual negotiations means negotiations between a distribution company and one supplier would satisfy the statutory requirement. Now, factually, on soliciting proposals, National Grid has already solicited multiple proposals. It participated in the RFP process, even though it chose not to negotiate a contract based on those results. And I expect that before the initial 5 years are up, it will participate in the second RFP process. There's lots of solicitation going on. But the department found first in that prior docket, the 09-138 docket, and then reiterated its finding in this docket, that the legislature meant what it said when it said that the distribution company can select among reasonable methods of solicitation, including competitive bidding, individual negotiations, or other methods. Individual negotiations, the department reasonably...
They do use the word proposals, plural, though, don't they?
They do use the word proposals, plural. The legislature also tells us in General Law Chapter 4 that a plural term will generally include the singular unless it's evident from the language of the statute that would be inconsistent with statutory intent. Here, an individual negotiation is sufficient. As we demonstrated in our brief, we often refer to negotiations between two parties in the plural, not as a negotiation, and there has been solicitation of multiple proposals.
Mr. Canoff had suggested that, that this approach, the individual negotiations, could end up in a lopsided arrangement between National Grid and perhaps one other provider of renewable resources. Well, what do you say about that?
Well, one thing the department said is...
It's anti-competitive, I guess is what he's saying.
Right. Section 83, of course, does not give National Grid or any other distribution company unbridled authority to enter into a contract. It requires department approval. This department approval, there was ample opportunity for parties to be heard. In addition to the Attorney General's Office of Ratepayer Advocacy, competitive suppliers, business customers, an entity whose mission for the past 10 years has been to try to prevent the Cape Wind project from happening, and many others, all were heard at great length by the department. And it was based on that expansive record that the department made its own findings that here the costs outweigh the benefits to ratepayers and the contracts in the public interest.
Are you saying, in response to Chief Justice Ireland's question, that before the individual negotiation between Cape Wind and National Grid, National Grid had solicited other proposals, so even if you use the plural, that word was satisfied? Or are you saying you don't really need to do that?
The department's primary position is National Grid did not need to do that. In addition, I was making the factual point that before and then after, when the RFP was redone after the suspension of the geographic provisions, National Grid, in fact, has solicited proposals. But the department's interpretation of the statute is that was not required, that it is sufficient for National Grid or another distribution company, if they can prove cost effectiveness and prove that a contract's in the public interest, to reach out and say, we think this one works. Now, of course, there's some risk to that, because the distribution company might not make its case, and the department might disagree and say, it's very nice that you thought this was a great deal for ratepayers. We disagree. We're not going to approve it. Here, National Grid did make its case, and the department so found.
Can I ask you to explain this, how the over-market costs will be spread amongst the various customers and how that's consistent with the restructuring legislation?
The restructuring legislation is not what governs here. We're dealing with Section 83. Mm-hmm. Section 83 contemplates two possible ways that power can be used. It can be sold into the spot market, and petitioners concede, as they must, that the legislature specified in that case any above-market cost gets paid by all customers, both basic service and competitive supply. The other thing they can do is what National Grid's doing here, which is to sell the power to basic service customers. Section 83 is silent as to what dollar amount has to be paid. Yes, a sale is happening. What's going to happen here is exactly what the legislature specified under the other set of circumstances. Here, the power will be sold to basic service customers at a market price. The department found that all customers share in unquantified benefits from this contract, even the ones that don't get the power. Remember, National Grid's buying energy, and it's buying renewable energy certificates also for the benefit of basic service customers, and it's buying capacity, critically important. And the department found that even the competitive supply customers share in the benefits of enhanced reliability, meeting the renewable energy portfolio standards, complying with the early part of the Global Warming Solutions Act, and so that above market cost will be paid by all customers, both competitive supply and basic service.
Yeah, I mean, it seems like power is sort of like cash. It's totally fungible. So how do you know what's being purchased from Cape Wind is going to customers X, Y, and Z versus other customers?
It is in part an accounting measure. I wish I knew more of the technology to explain how one can keep track when power is coming just from offshore and being used by basic service customers on Cape Cod versus National Grid customers in western Massachusetts.
Does Section 83 also require that before National Grid can spread the cost around to all distribution customers, that it has to have entered the wholesale spot market?
No, it does not. The petitioner's suggestion that the statute says that is incorrect. Essentially, the petitioners are asking the court to read into the statute something that the legislature did not choose to put there. All that the legislature says is that the power can be sold to basic service customers. That's what's happening here. They will pay for it. Any suggestion in the early briefs that somehow basic service customers would get something for nothing is incorrect. But basic service customers will, number one, pay the fair market value of the power, and number two, they'll share with all other customers in the above market cost. This is not something for nothing. The department looked at what the typical basic service customer would pay extra per month, found that a typical household would pay about 95 cents more per month than without this contract, and determined, as the legislature directed it to, that the benefits to those customers made that worth it. Now, with respect, very briefly, on the Dormant Commerce Clause issue, there was a new assertion by the Alliance in its reply brief that the department had no power to decide whether the geographic provisions of Section 83 were constitutional. So I just want to point out what I hope is already obvious. The department did no such thing. The department exercised authority that the legislature gave it to suspend those provisions. It didn't have to decide whether the provisions were unconstitutional, and that issue is not a live issue before the court at this time.
So you're saying we don't have to decide that?
That's correct, Justice Spotsford. What the department found, and this is amply supported by substantial evidence, was that National Grid would have entered into this contract with or without the geographic limitations. And as a matter of law, of course, National Grid was free once those provisions were suspended to say, well, in that case, never mind, we're no longer interested, we're going to withdraw our petition, we no longer want to do business with Cape Wind, but they didn't do that. And so there simply is no state action here that required National Grid to discriminate against out-of-state power suppliers. Indeed, Cape Wind itself, of course, is an out-of-state power supplier. It's outside Massachusetts waters, as the court will recall from last year's Alliance case.
Now, would there have been a problem if the DPU, in evaluating the price negotiated by National Grid, would have used the existing Commerce Clause restriction or the existing restriction with regard to state distribution?
If the department had, say, not suspended the provision
Right.
and had required that National Grid comply with it, we're not sure what the answer would be because of the fact.
Apart from that, they didn't do that. I know that. But if they had indeed evaluated it and considered only in-state alternatives, you say they considered alternatives from everywhere, including Canada, I gather, correct?
Yes, Your Honor.
Okay.
And of course, they bought out-of-state power from Cape Wind.
Okay. But if so you say they were not bound by the in-state limitation in their evaluation of the appropriateness of this contract?
That's correct.
Okay. If they believe they were bound, would that require remand?
If they believed that they were bound. The National Grid and Cape Wind have made arguments pointing out that Cape Wind not being an in-state resource, there wouldn't be, under that hypothetical, a dormant Commerce Clause violation anyway.
Okay. Apart from whether it's a Commerce Clause violation, would it have been a shortcoming of the appropriateness of the DPU evaluation?
I can envision the arguments that it would be, Your Honor, but it is, of course, a counterfactual.
Okay, and I guess that's my next question is how do we know from the record? They say they did that they considered out-of-state sources. Where in the record are we going to find that they in fact did what you say they did?
There is extensive testimony from two individuals who are employed by National Grid who procure power throughout New England and New York about their familiarity with not just availability of supply, but market pricing of other renewable energy sources. There is testimony from Dr. Susan Tierney, former chair of the DPU, who was hired by National Grid to canvass what was likely to be available in the foreseeable future throughout the New England region, in New York, and even in Canada, despite the fact that there's not the transmission capacity available now to bring it there. The department made specific findings, this is around pages 308 to 309 of the department's order, that National Grid decided it made sense for its ratepayers to enter into a contract with Cape Wind because of the kind of unique attributes that we've already discussed some here this morning. I should also note, just because it was a new thing in the Alliance's reply, the Alliance cites a 1985 case from the Eighth Circuit and asserts that this case stands for the proposition that mere approval of a contract by a utility regulator can violate the Commerce Clause. In fact, that case did not have to do with contract approval. In that case, there was a contract that had been in effect for about 10 years under which out-of-state power was being purchased. And the State Public Utilities Commission at that point wanted to void the contract ab initio because it didn't want the utility to bring power from out of state anymore. Unsurprisingly, the Eighth Circuit found that that was state action discriminating against out-of-state electricity, and that stated a claim for a violation of the Commerce Clause. Here, not only did the department not require National Grid to refrain from contracting with an out-of-state supplier, they went much further, and as we just discussed, required National Grid to demonstrate that even if the geographic provisions had been suspended earlier in time, that National Grid still would have chosen to contract with Cape Wind. This scenario that National Grid found itself under, the department found was very different than NSTAR. NSTAR had wanted to enter into contracts through an RFP process that had been geographically limited, the department, exercising reasoned consistency, found that that was different from a situation where National Grid, for its own reasons, chose to negotiate with a single supplier and was able to make its required showing that that contract was cost-effective and in the public interest.
Thank you.
Thank you.
Good morning. May it please the Court. David Rosenzweig for National Grid and Cape Wind. I would start by just saying I join argument with Assistant Attorney General Salinger on the Commerce Clause argument. And just to address Justice Gantz's question, National Grid presented a series of witnesses from their senior-most executives who were in charge of power procurement that they were involved in renewable energy procurement in Rhode Island and in New York. They were familiar with what other prices were in the region. They presented a gap analysis showing what where the presence of different renewable resources were located, what the demand for renewables would be, and that there would be a significant gap. There was testimony from the Alliance's witnesses itself in terms of what alternative resources might cost, be they land-based wind or solar, from in the region or out of the region. So there was evidence from both sides from which the department could weigh and find that it had a sufficient record to determine that a price and non-price comparison could be made to the Cape Wind individual negotiation. And I refer the Court particularly to pages 229 and 230 of the Department's order, where the issue of opportunity cost is specifically addressed. It's not under that context per se as the label the Department applied, but they did find that the benefits to be accorded the Cape Wind PPA to National Grid's customers far exceeded any other resource, Section 83 compliant resource, that National Grid could procure, given a variety of characteristics of Cape Wind. There are 7 there that are identified. The one I'd like to point out and underscore to the Court are compliance costs that National Grid's customers will incur, and other distribution customers in the state, for the Global Warming Solutions Act, which is an act that was passed by the legislature in the same time frame as the Green Communities Act in Section 83. And the Global Warming Solutions Act sets very aggressive targets for greenhouse gas emission reductions that must be achieved in the electric sector and other sectors compared to 1990 levels. It sets targets of 25% reduction of greenhouse gas reductions by 2020 and 80% greenhouse gas reductions compared to 1990 levels by 2050. The Department found, based on the record evidence, that Cape Wind would be the single largest electric sector Global Warming Solutions Act source of benefits by reducing the cost of compliance that would otherwise be incurred. The numbers in the order are on the order of 14% of the electric sector by 2020. That amount alone, the Department said, quite possibly outweighs any of the above market costs, not even taking into account the myriad other benefits that they found in terms of its size, its maturity, its location, its higher capacity factor, its dedicated transmission line that is lacking for other resources that are out of the state or out of the region that would have to build those transmission lines. Those have costs, those have uncertainties. So that Cape Wind was unique in that regard by not having those types of costs, presented benefits to National Grid's customers that outweighed any of the costs, not only of the above market portion of the Cape Wind contract, but in comparison to any other resource was superior in meeting the goals and statutory standards of Section 83. The Department went even further than that, because on page 233 they said even a combination of smaller renewable resources, taking size out of the equation, would not achieve the same benefits as Cape Wind would achieve for its size if you take and aggregate a bunch of smaller, let's say, land-based renewable resources. Even that scenario, which might result in perhaps a lower cost and a lower level of above-market cost, would be far exceeded by the benefits that would not be realized by not taking the Cape Wind contract, given Cape Wind's capacity factor, which will be higher than land-based wind, its location near a major load center, its dedicated transmission line, its stage of permitting, which was in advance of many, if not most, land-based wind projects that were compared during the proceeding. So there's an ample record on those issues, and as Justice Gantz's question Attorney General Salinger said there's a substantial record, and the parties below presented their own evidence. On brief, they really don't argue that there was a lack of substantial evidence on those issues. Quickly addressing the issue of cost recovery, the proposal that National Grid presented achieves exactly the purposes of Section 83. The rate-making approach that's dictated in Section 83 addresses only one circumstance, and that is where the power in the RECs is used to be supplied to the wholesale market, and then there's a crediting or debiting of that power to customers. It doesn't address the circumstances that apply here, which is National Grid using the power to supply to its customers directly for basic service and to use the RECs in the same manner. But the department looked at that very closely in a 30-page section of its order. It determined the same result that would be occurred if the first approach was being used would be economically achieved under the cost recovery approach the National Grid proposed. They found that the statute was silent on that particular scenario, and they recognized National Grid was an international company that had an accounting standard that required it to use any power it obtains for what's called own use under the accounting standard, thereby not allowing National Grid to go to the wholesale market indirectly and use the financial transaction of crediting or debiting. National Grid was required by that financial standard, accounting standard, to go and use the power for its own use, and then to achieve the same economic result as would occur if it used the specific cost recovery approach that is outlined in the statute. And I just underscore that the statute is silent with regard to what happens when a distribution company uses the power in the RECs for its own use. So the department looked at the benefits that will go to both basic service customers and all distribution customers from the Cape Wind contract, and achieved a result that was based on the evidence and achieved the same economic equivalent result. Thank you.
Thank you, Counsel.